The case of the state of Ohio versus Michael T. Dixon. Case number is 20 CR 0201. And Mr. Dixon is present along with his attorney, Mr. Baum. And Mr. Pearson is here representing the state of Ohio. And we've been at a jury trial for approximately the last week. And the jury went out to deliberate at 10:35 this morning, and my understanding is at this point that they have a verdict. Did you identify one of your members as being the foreperson?
Yes.
All right, thank you, ma'am. And it appears that you've already turned these over to the bailiff?
Yes, Your Honor.
All right. And at this point, the court will examine the verdict forms to make sure they are in proper order. The verdicts appearing to be in order, the court will publish them at this time. We, the jury, being duly sworn and paneled, find that the defendant, Michael T. Dixon, guilty of murder, an unspecified felony, as charged in the indictment, in that defendant did purposely cause the death of James Thomas Whitaker. And all 12 jurors appears to have signed. Moving on to the firearm specification. Excuse me. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, did have or had a firearm in his possession or under his control while committing murder, and it's signed by all 12 jurors. Moving on to the verdict form on count 2, murder. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, guilty of murder, an unspecified felony, as charged in the indictment, in that the defendant, Michael T. Dixon, caused the death of James Thomas Whitaker as a proximate result of committing felonious assault. And verdict on firearm specification is to count 2. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, did have or had a firearm in his possession or under his control while committing murder as the proximate result of committing felonious assault, signed by all 12 jurors. Verdict form as to count 3, felonious assault. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, guilty of felonious assaults, a felony of the 2nd degree, as charged in the indictment, in that he caused physical harm to James Thomas Whitaker by means of a deadly weapon, to wit a firearm, signed by all 12 jurors. Verdict on firearm specification is to count 3. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, did have a firearm or had a firearm in his possession or under his control while committing felonious assault, signed by all 12 jurors. Verdict form on count 4, tampering with evidence. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, guilty of tampering with evidence, a felony of the 3rd degree, as charged in the indictment, in that he produced cranial fractures to the skull of James Thomas Whitaker, signed by all 12 jurors. Verdict form on count 5, tampering with evidence. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, guilty of tampering with evidence, felony of the 3rd degree, as charged in the indictment, in that he broke and or cut the bones of James Thomas Whitaker, signed by all 12 jurors. Verdict form on count 6, tampering with evidence. We, the jury, being duly sworn and panel, find the defendant, Michael T. Dixon, guilty of tampering with evidence, a felony of the 3rd degree, as charged in the indictment, in that he placed the body of James Thomas Whitaker in a burn pit and set it ablaze, signed by all 12 jurors. Verdict form on count 7, tampering with evidence. We, the jury, being duly sworn and impaneled, find the defendant Michael T. Dixon guilty of tampering with evidence, felony of the third degree as charged in the indictment, in that he cleaned and rearranged the location where James Thomas Whitaker was killed. And that's signed by all 12 jurors. Moving on to verdict form count 8, tampering with evidence. We, the jury, being duly sworn and impaneled, find the defendant Michael T. Dixon guilty of tampering with evidence, a felony of the third degree as charged in the indictment, in that he stole, sold, or destroyed a flat screen TV, signed by all 12 jurors. Verdict form on count 9, tampering with evidence. We, the jury, being duly sworn and panel, find the defendant Michael T. Dixon guilty of tampering with evidence, a felony of the third degree as charged in the indictment, in that he produced the fraudulent suicide note purported to be written by James Whitaker, signed by all 12 jurors. Verdict form on count 10, tampering with evidence. We, the jury, being duly sworn and paneled, find the defendant Michael T. Dixon guilty of tampering with evidence, felony of the third degree, as charged in the indictment, in that the defendant disposed of a Winchester 1400 and a Remington 1100 firearms, signed by all 12 jurors. Verdict form on count 11, abuse of a corpse. We, the jury, being duly sworn and impaneled, find the defendant Michael T. Dixon guilty of abuse of a corpse, a felony of the fifth degree as charged in the indictment, in that he treated a human corpse in a way that would outrage reasonable community sensibilities, signed by all 12 jurors. Verdict form on count 12, sexual battery. We, the jury, being duly sworn and impaneled, find the defendant Michael T. Dixon not guilty of sexual battery, a felony of the third degree as charged in the indictment, in that he did engage in sexual conduct with Melody Dixon, not his spouse, and he being the father of Melody Dixon, signed by all 12 jurors. And finally, verdict on count 13, engaging in a pattern of corrupt activity. We, the jury, being duly sworn and panel, find the defendant Michael T. Dixon guilty of engaging in a pattern of corrupt activity, a felony of the first degree as charged in the indictment. We do find beyond a reasonable doubt the defendant from and about the third day of July 2020 through the 25th day of July 2020 in Hocking County, Ohio, while employed by or associated with the enterprise, conducted or participated directly or indirectly the affairs of the enterprise through a pattern of corrupt activity, signed by all 12 jurors. So it appears we have verdicts as to all counts. And Mr. Baum, would you like the jury polled?
One moment, Your Honor.
Certainly.
Your Honor, this time the defendant has indicated he wishes to waive that.
Wishes to waive that? All right. So at this point, ladies and gentlemen, your service as jurors has come to an end. I want to express my sincere appreciation for your services in performing this important public function. Our judicial system, as we know it in the United States, is the finest in the world, and it's very important in preserving our rights as citizens. And I'm sure you willingly agree at this point to serve as jurors in the cause of action just completed. And by you being here and participating, you're helping guarantee the continued existence of law and social order in our country. And as indicated earlier, after your verdict has been returned and your jury service is complete, you may discuss the case with anyone, but you're not required to do so. Whether you discuss this case with counsel or anyone else is after you are discharged is a matter of your own choice. I'm going to have you stay here for the purposes of getting your script and also to debrief you, so you'll be out in the hall in a moment. At this point, the court would continue the defendant's bond, and also the court would order a pre-sentence investigation. Yes.
Your Honor, may I address bond?
Yes, sir.
This time, the state would request that the defendant's bond be revoked. I believe he currently has a $1 million bond, but that was before he was convicted of killing James Whitaker. Now he has been convicted of multiple felonies. He's looking at serving a long time in prison, a life sentence. So the state would request that his bond be revoked and he be held with no bond pending sentencing. Thank you.
Thank you. Mr. Baum?
Your Honor, to this point, he has not been able to make bond. I don't believe at $1 million he would be able to make bond. We feel that's an appropriate amount considering that he has been incarcerated since the outset of this case, so we think bond's appropriate where it is. All
right, I think I'll follow the prosecutor's suggestion, no bond then. All right. So at this point, the court is ordering a pre-sentence investigation. Anything else to come before the court at this time, Mr.
Nothing
Pearson?
additional, Your Honor. Thank you.
Nothing from the defense this time, Your Honor. Thank you.
All right, very good. So at this point, court will excuse everybody except the jury, including the defendant. And so I'd like to thank you once again for your service.